Good afternoon, everybody. Good early afternoon. It's 12 on the nose. My name is Mark Carter. I'm a professor here at the College of Law, and I'm chair of the Speakers Committee this term. Welcome to everyone who joins us today in person and everybody who is able to join us watching on live stream as well. As we begin today's event, I acknowledge that we're gathered on Treaty 6 territory and the ancestral homeland of the Métis people. And in honoring this land's rich history, we pay our utmost respect to the First Nations and Métis ancestors who have shaped this place. And in doing so, we reaffirm our profound connection with one another. Today, it's our pleasure to welcome Professor Dino Kritsiotis, who is the holder of the 2025 Ariel F. Sallos Chair in Human Rights at the College of Law. The Sallos Chair was created thanks to a generous donation by Ariel F. Sallos, a USask law alumni, class of 1931. And he and his law partner first opened their doors in their firm in 1932 in the depths of the Great Depression. They persevered, and the firm celebrated its 50th anniversary in 1982. And that same year, the University of Saskatchewan awarded an honorary degree to Dr. Sallos, recognizing his decades of community service outside his law practice. And that included serving on the University of Saskatchewan Senate and playing a key role in setting up free law bureaus for clients who could not afford to hire lawyers. This happened long before legal aid was established in the 1970s. In 1979, Dr. Sallos established a trust fund to support the Sallos Chair in Human Rights at the College of Law. The first chair was appointed in 1986, Dr. Virginia Leary. We are grateful to Mr. Sallos for his gift and the nearly 40-year legacy of the Sallos Chair in Human Rights here at the College of Law. I'm now pleased to introduce Professor Dino Kritsiotis, our current holder of the Sallos Chair. Dr. Kritsiotis is a professor of public international law at the University of Nottingham, where he has taught since October 1994. And he serves as the director of the Nottingham International Law and Security Center, and he's the founding head of the International Law Humanitarian Law Unit. Professor Kritsiotis is recognized authority in the field of public international law. He specializes in the legal regulation of force and armed conflict, as well as the history and theory of public international law. Among his many publications are the conceptual and contextual perspectives on the modern law of treaties, published by Cambridge University Press, and his lectures on intervention and the problematization of consent in the Max Planck Trialogues on the Law of Peace and War, Volume 4, Armed Intervention and Consent. Professor Kritsiotis also serves as co-editor of the Cambridge History of International Law, Volume 12, International Law After the Cold War, and it is due to be published by Cambridge University Press in the next year. And Dr. Kritsiotis sends a special welcome to the members of the Sallos Seminar who are with us today. That's a course that the Sallos Chair holds each time they are visiting with us. So please help me Please help me welcome Professor Dino Kritsiotis for our lecture today.
Thank you, Professor Carter. Dean Martin Phillipson, colleagues within the College of Law, dear students of Law 833, the Sallos Seminar, I begin too by acknowledging that this land is Treaty 6 territory, the traditional territory of the Cree peoples, and the sacred homeland of the Métis Nation. It's a particular pleasure and indeed a great honor for me to appear as the current Ariel F. Sallows Chair in Human Rights at the University of Saskatchewan. I do so and deliver the annual lecture recognizing a man who, by all accounts, as you've just heard, was not an average citizen. For the life record he achieved beyond his career as a corporate lawyer and serving as a solicitor for the city. We do know that he traveled widely in his later years, that he adored debating. There's a poster right outside my office to that effect, and that he was a carer for his mother in her final years. He died in 1984. Please allow me also to thank each of you for your supremely warm prairie hospitality since my arrival in the city. That has been measure for measure out of all proportion to the extreme temperatures that have greeted me in what I understand is an impossibly cold year. A particular shout out to Dean Phillipson for his generous invitation to and initial tour of the law school, and to Katie Richard and Chris Harris, both of whom have ensured a most harmonious landing into my new surroundings. And yes, I'm adjusting to the brutal minuses of outdoor living, especially after my freezing first night in the city. My adage ever since has been, frost Britain twice shy. Perhaps by way of preliminaries, I should set the record straight on some of the nomenclature, quite fitting for a lecture that has names somewhere in its title. The official designation of the chair honoring Ariel Franklin Sallows concerns human rights, which for many a public international lawyer has connotations with the period after the Second World War, marked by the adoption of the UN General Assembly's Universal Declaration of Human Rights. That specialization within the discipline has gone on to even greater things, with twin covenants on civil and political rights, as well as economic, social, and cultural rights, both of December 1966, and a range of regional instruments and infrastructures, and thematic pronouncements besides. Racial discrimination, for instance, on the elimination of all discrimination against women, on Indigenous peoples. As members of my Sallows seminar can attest, my field of interest and specialization is somewhat different, since it has a much older history and dates back to the 19th century, originally known as the laws of war, but now operating under the moniker of international humanitarian law. It also proceeds from different premises to the inherent rights of individuals and of certain types of groups. Its organizing mindset, if I can call it that, is that the soldier has the right to kill another soldier. And so we need to be alert to the ethos and sensibilities of that law, which takes armed conflict and indeed violence occurring within armed conflict as a given. It would be a mistake not to acknowledge this from the outset, or to assume that the law's ambitions were anything otherwise. Perhaps it would be helpful to turn to a specimen of these ambitions in early form from the very first, the original Geneva Convention of 1864. You can't read that, so you have to take my word for what I'm about to tell you. This is the Geneva Convention for the amelioration of the condition of the wounded in armies in the field. I take note of the quaintness of the term amelioration here, the law making clear that it was not the law's purpose to abolish the enterprise of war, but rather to ameliorate, that is, to regulate and to cushion, its forbidding effects on human beings. It took as its constituency the wounded or sick soldiers befallen of battle, with the idea that some care and comfort could be administered to the survivors of violence. Protections were then afforded in the convention to ambulances and military hospitals, but also to medical personnel and staffers, and to the inhabitants of the country who may bring help to the wounded. What a wonderful exhibition of humanity that enveloped civilians into an emerging ethics of compassion and care. What an advance for the human species. Let us get ourselves quickly to the next war. Observe, though, how these arrangements did nothing to disturb the fundamentality of permissible killing, wrought by the occasion of warfare itself, and the mentality, as was expressed a mere 4 years later in the Declaration of St. Petersburg of 1868, that the only legitimate object which states should endeavor to accomplish during war is to weaken the military forces of the enemy, and that for this purpose it is sufficient to disable the greatest possible number of men. More euphemisms from the law. Weaken the enemy, disable the greatest possible number of men. What is noticeable from this document is that the law did not move to curtail the amount of killing of the military forces of the enemy. These were fair game, and after all, was not that the entire purpose of war? No equation of violence was therefore made, no equation between means and ends. What the Declaration of St. Petersburg did do was rain down on what it called the employment of arms which uselessly aggravate the sufferings of disabled men or render their death inevitable. In other words, on how combatants were killed, not on whether they were killed, and not on how many were killed. In this instance, projectiles under 400 grams in weight that exploded upon contact with the human flesh were outlawed, another choice demonstration of the law's proclivity to draw invisible lines between necessary and unnecessary suffering. The chosen subject for my lecture today is a much used but rather elusive principle from the international humanitarian law canon. That is the so-called principle of proportionality. The lecture will unfold in the following way. I shall try first to set out the stall on the formal articulation of proportionality, concentrating on how it is framed and the work that it is designed to do as a matter of conventional and customary international humanitarian law. Once that is behind us, I shall share some musings on the civilian population, as the principle was devised with that idiom in mind, with the idea that some of its complexity will be unpacked and possibly better understood. Then, something shall need to be said on the operationalization or the pragmatics of the principle of the proportionality calculus. It would be useful to have some of the main indicators for its use in practice before we approach any hint of application. And finally, there shall be an opportunity to reflect on the recent experience of Gaza, not so much projecting forth answers, but asking whether in truth we are asking all the right questions about violence undertaken in the name of proportionality. And then hopefully there will be some time for questions and feedback. To my first part, a brief introduction to the principle of proportionality and the context in which it has taken shape as a legal proposition. As we have just seen with the 1868 St. Petersburg Declaration, it had no cleavage in the event of violence directed against the decimation of the combatants of the enemy side. Along similar lines, we might posit too that it has no place when civilians are made the target of deliberate attack, as they were in Israel in the early morning hours of October the 7th, 2023, when some 1,200 individuals met their final fate and a further 239 were abducted hostages. This is because proportionality is postulated upon the principle of distinction, a point that I intend to amplify anon. Where the principle was given its main conventional expression was in Article 51(5)(b) of the first additional protocol of the Geneva Conventions of August 1949. This was adopted in June 1977, and it provided as part of its adumbrations on the protection of civilian population that indiscriminate attacks would be outlawed, and that these would include an attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. That's a really important provision. As stated then, The principle was designed as a safeguard against the occurrence of excessive incidental loss of civilian life, a form of words that suggests that the attack in question must have been directed in the first place against a military objective. And indeed, it is against that background that the principle of proportionality derives its purpose and core meaning. Astute observers will have realized that there is no naming of proportionality as such in this provision. All we are given in Article 51(5)(b) is a direction to weigh or balance two marked considerations: that of the concrete and direct military advantage anticipated by a given attack, as against the projected incidental losses to civilian life and objects occasioned by that attack, whatever those might be deemed to be. One might, of course, surmise that this equation is an exercise in planned futility orchestrated by the law itself, bringing into the same orbit as it does the twin imponderables of, on the one hand, anticipated military advantage yielded by an attack, and on the other, expected incidental losses, in order to assess whether somehow the one imponderable is not fully out of sync with the other. Still, there remains the background assumption that the attack in question is being directed against some military objective or other, and that proportionality attends to the consequences of its total or partial destruction, capture, or neutralization. And it is not too difficult to understand why this relation might be so. In the elaborate negotiations that accompanied the drafting of the protocol, Canada had expressed concern for the situation where a single civilian near a major military objective whose presence might deter an attack. And the United Kingdom was of the view that it was difficult to visualize an attacker who would not carry out an assault upon an entrenched adversary because of the presence of one or two civilians. Many decades hence, in the targeted killings case of the High Court of Justice of Israel in December 2006, President Emeritus Aaron Barak took as his hypothetical the ordinary case of a combatant or terrorist sniper who is shooting at soldiers or civilians from the balcony of his home. Shooting at him will be proportionate, he reasoned, even if as a result of an innocent civilian who lives next to him or who passes innocently next to his home is hurt. This is not the case if the house is bombed from the air and dozens of residents and passers-by are hurt, he intoned. For President Barak, the hard cases are those which are in the space between the extreme examples. By all accounts, then, what we might say is that some metric or mechanism had to be brought into being in order to leverage against some kind of excess. Lawyers always love speaking in ambiguities. And that while the identification of a military objective constituted something of a permissive function, that did not or could not entail a green light to untold or endless killing. This is where the principle of proportionality comes into its own. Its controlling or restraining function set against the freedom ushered to strike military and thus lawful objectives. Although in this we should be luminously clear, the principle of proportionality is not against all loss of civilian life. It is not even against incidental loss of civilian life. Its prescription is against excessive incidental civilian losses. True to form, the principle of proportionality occupies part of the ground mapped by the basic rule on distinction, also articulated in Article 48 of that same protocol, which stipulates that in order to ensure respect for and protection of the civilian population and civilian objects, the parties to the conflict shall at all times distinguish between the civilian population and combatants and between civilian objects and military objectives, and accordingly shall direct their operations only against military objectives. I said in my introductory remarks that it would be useful to share some reflections on the said civilian population. since the principal features in a provision whose rubric is stated to be the protection of the civilian population. And I presume that that might have something to do with any act of treaty interpretation. The civilian population is defined elsewhere in the additional protocol as comprising all persons who are civilian, providing, in my view, an altogether greater degree of visibility for the civilian population than had ever existed previously. Contrast the main rule on targeting appearing in the Hague Regulations, annexed to the Hague Convention number 4 of 1907. We're going way back now, which stated in coolly detached language that the attack or bombardment by whatever means of towns, villages, dwellings, or buildings which are undefended is prohibited. No civilian population in sight, at least as summoned in this Spartan legal prose. Who can ever imagine entire towns, villages, dwellings, or buildings no less, without any civilian life? Where was the civilian and where was the civilian population in the mind's eye of the authors of those Hague Regulations? It's too late to ask them. Things fared a little better with the 1949 Geneva Conventions, and in particular Geneva Convention 4, relative to the protection of civilian persons in time of war, where the civilian population of occupied territory made an appearance 4 times, with a singular nod to the civilian population of the occupying power. What is critical in my view, though, is that there are certain moments in Geneva Convention 4 where it was thought apposite to disassemble the civilian population into its component parts, precisely because it was thought that additional protections were called for. I single out Article 17 of Geneva 4, which requires parties to the conflict to endeavor to conclude local agreements for the removal from besieged or encircled areas of wounded, sick, infirm, and aged persons, children, and maternity cases, and for the passage of ministers of all religions, medical personnel, and medical equipment on their way to such areas. A hopeful corrective to the otherwise coarse instrumentality of siege warfare. There is also Article 23, and I want us to look at this because Article 23, you'll see in the highlighted phrase, permits the free passage of all consignments of essential foodstuffs, clothing, and tonics intended for children under 15, expectant mothers, and maternity cases. Note that's not the case with regard to the first part of that sentence, which talks about the free passage of consignments of medical and hospital stores. Medical and hospital stores, not foodstuffs, and objects necessary for religious worship intended only for civilians of another high contracting party. This is a classic example, Article 23, of the message I want to take away today, that the civilian population works for some things, but then we have to break down the civilian population for other things. So it can be said that the law has traversed considerable distances from the time of the Hague Regulations and the First World War, when the civilian population was not even formally entered into the dramatis personae of the humanitarian corpus, through to the consciousness that designated as a target in its own right, with the chilling practices of the Second World War, and then Geneva Convention 4 and the additional protocol. But rather than take this fact as a given as we endeavor to eke out a meaningful proportionality during hostilities, it should be equally clear that any dogmatic beholdenness to the civilian population as such might need to be tempered in view of the logic that brought us the divisibility of the civilian population that is very much at work in Geneva Convention 4. Now let's turn to some observations about the operational aspects of proportionality before we train our sights on the actual experience in Gaza. The first might not seem all that obvious, but in a realm of ritual uncertainties, there's an important certainty that comes hurtling to the fore when we remind ourselves that the principle of proportionality operates not only within international humanitarian law, but also within the context of the laws of the jus ad bellum, a logically prior series of postulates that address the question of when states can initiate force internationally, for example, the right of self-defense, or perhaps even a right of humanitarian intervention. They are, in a sense, the laws applicable pre-armed conflict and include the principles of necessity and proportionality, principles which have conditioned the lawful exercise of the right of self-defense ever since they were set down by U.S. Secretary of State Daniel Webster in the famous Caroline Correspondence of 1841. There, Secretary Webster stipulated that the act justified by the necessity of self-defense must be limited by that necessity and kept clearly within it. Secretary Webster insisted that the self-defending states do nothing unreasonable or excessive with their actions, words that have been understood to mean nothing unreasonable or excessive in the military operation when taken as a complete whole. The principle of proportionality at this point of application therefore parallels to a great extent the restraining function of proportionality within IHL. But the calibration is different, and that is why we may wish to refer to proportionality in this context as macroscopic proportionality. It's measuring the entirety of violence within the operation. Now, as we know, within the context of IHL, the principle of proportionality is not probing of all the violence committed in terms of a given exercise of self-defense or military operation, assuming, of course, that can ever be appropriately calibrated or quantified. What the law is insisting here in this context of IHL is that violence committed in respect of each and indeed every military objective must square with the proportionality metric. The law at this moment is not investigating the violence of the overall military campaign, but is concerning itself with the violence at the granular level, as against each military objective and the bid for its total partial destruction, capture, or neutralization. We might therefore want to think of this in terms of what I call microscopic proportionality, to helpfully recognize the different pursuit to assessing proportionality of the jus ad bellum, while acknowledging that they might overlap temporally. We might also say that whereas macroscopic proportionality intends to deliver a singular computation under the jus ad bellum, we envisage a host of such assessments to be made under IHL, and that their effect is one and the same. It is to adjudge the overall lawfulness of the violence in question. All of this to the good. But who gets to decide what is proportional and what is not proportional? To my second observation, it seems to me that the various questions envisaged by the protocol, the additional protocol we looked at earlier, the identification of military objectives, the calculation of excessive incidental loss of civilian lives, the taking of necessary precautions, and so on and on and on, must realistically be engaged by the belligerent parties in the first instance. It is they who must and invariably do make the call on whether their actions comport with conventional and customary humanitarian law. However, the matter can surely not be allowed to rest there. Otherwise, the satisfaction of these provisions would ultimately reside with the say-so of the attacker, and that would be an entire subversion of international law and the international legal process. In any event, all of the high contracting parties to the conventions and the additional protocol are under the solemn obligation to respect and to ensure respect for those laws in all circumstances. And how proportionality has been understood and applied or misapplied is deserving of that respect. That said, just because a state has not attracted the public censure or criticism of one of these high contracting parties for behavioral lapses should not be read as the entirety of exchanges that have occurred. Not all of these interactions are made the stuff of public fodder. Some are, some aren't. And we should not expect to see them hoisted in the sphere of political theater or spectacle. Not everything is tweetable. However, some of what has been seen does not inspire great confidence, certainly to this mind, as when the then British Defense Secretary Grant Shapps was pointedly asked on national television in November 2023, whether he thought Israel had, quote, gone too far in its response to the horror of what happened. His reply: the UK believes strongly that Israel must act within international humanitarian law. One can only marvel at how a jus ad bellum question was answered by reference to the entirely separate predicate of international humanitarian law. All the more reason for us to distinguish between macroscopic and microscopic proportionality. But if politicians do choose to enter the legal fray in this way, they really should be in full command of their brief. By his response, was the Defense Secretary to be taken as saying that the UK does not believe that Israel must comply with the jus ad bellum, the law of the United Nations Charter? Are only the Geneva Conventions an issue, in his view? Otherwise, why mention international humanitarian law and only international humanitarian law in response to that question? Or was he conceding that the United Kingdom believed that Israel was not acting in accordance with international humanitarian law? Why then make the statement that the United Kingdom believes strongly that Israel should act lawfully? Could it ever have been, and was it ever otherwise? Let us now turn, in the final part of this lecture, to the application of the principle of proportionality in respect of the targeting decisions of Operation Swords of Iron, Israel's military response to the tragic and traumatic events occurring on its territory on that horrific day of October the 7th, 2023. Here, the overwhelming sensation through to the ceasefire announced just last month has been on the sustained intensity of hostile activity, which included nearly 30,000 munitions into Gaza in the first 7 weeks of hostilities, more than in the next 8 months combined, with more than 7,000 targets in the first 19 days of action. And then the inescapably high casualty levels. Just last week, the Palestinian Health Ministry set its running toll at 47,583 lives. Speaking to the nation soon after the ground operation had got underway in October 2023, and reaching for the explanatory power of earlier precedent, Israel's Prime Minister Benjamin Netanyahu said this: in 1944, the Royal Air Force bombed the Gestapo headquarters in Copenhagen, a perfectly legitimate target. But the British pilots missed, and instead of the Gestapo headquarters, they hit a children's hospital nearby. And I think 84 children were harmed and burned to death. That is not a war crime, he reasoned. That is not something you blame Britain for doing. Setting aside the complexity of human error of that incident, the compartmentalization of violence and its requisite consequences in this way does seem to me to be precisely what microscopic proportionality is demanding. And Israel does appear to understand this, because later in December 2023, it admitted that 2 strikes it had undertaken on the Al-Maghazi neighborhood of Gaza had hit additional buildings near the targets, which likely caused unintended casualties to additional unintended civilians. If we recall the words of President Emeritus Barak from the targeting killings decision, this would mean we are now knee-deep in the hard cases and not in the excesses. Be this as it may, Israel expressed regret for the harm it had caused in an episode in which dozens were reported to have been killed. Importantly, a close examination of violence requires just that order of tally. It is definitively not a comparison of the ratio of killed combatants to killed civilians, to hostilities recently or long since past. The context for these statistics is not in doubt. Shaken by the horrors of October the 7th, Israel set to vastly expand its compass of targets to pursue not only senior Hamas commanders, arms depots, and rocket launchers that were the focus of earlier campaigns, but also the lowest-ranking fighters of the organization. Within hours of the attack, and in the very same order, military leadership in Israel had provided the authority to risk killing up to 20 civilians with each target, departing from its earlier practice. We can add to this that the recent testimony of 6 intelligence officers has suggested that the use of Lavender, an AI system deployed for accelerated target selection. So perhaps it is small wonder that these figures are where they are. If I may, I would like to return in my closing moments of this lecture to some of the overall numbers already mentioned. I do so conscious of what I have said again and again on the demands of microscopic proportionality. And I do so aware of the politics and the reliability of the source of these statistics. Indeed, any statistics coming forward from the white heat of warfare. But I think there are important phenomena presented as to the global picture which matter to what has been said here today. Just a few days ago, the Lancet Medical Journal in London published an important study in which research indicated that the death toll in Gaza during the first 9 months of hostilities was about 41% higher than numbers disseminated by the Palestinian Ministry of Health. That is an alarming fact, if true, and it speaks to the real fragility of accurate numbers while warfare is raging, for no doubt a whole host of circumstances. More disturbing for me, though, was the finding in the same study that women, children, and people aged 65 years or older counted for 59.1% of the deaths. A staggering 59.1% of these deaths due to traumatic injury. There, right there, not in the sacred humanitarian texts of our time, but in the neon lights of these figures and the graphs and the statistics, are the disproportions of violence, the truths not borne by proportionality, by microscopic proportionality, laid bare. Let us read again, together, the relevant bit of the additional protocol of June 1977. Yes, the visibility that document has brought to the civilian, to civilian life, to the civilian population more generally. But what is one to make of the many children who have lost their lives, whether in Copenhagen in 1944 or the Gaza of today? Is a child's life, or in the register of Additional Protocol 1, the civilian life of a child, properly captured by the abstractness, the assumptions, the projections of 1977? Is a child's life really to be counted the same as a life half-lived, or that lived to the full? Or has the time come for us as humanitarians to ask, despite all its achievements, what has proportionality made obscure? Thank you. That's perfectly pronounced, by the way. I must compliment you on that.
Oh, and can I ask you to use the speakers or the microphones?
I'm Robin Hansen. What other principle might work, broadly speaking? I agree. It's, well, I don't know, maybe I shouldn't put words in your mouth, but to me it doesn't really seem to be standing up to the challenge of making warfare a little less horrendous. Thank you.
Do you want to take a few questions, or can I respond to that? Thanks, Professor Hansen, for that question. I think that the compulsion of international humanitarian lawyers with every armed conflict is to apply the law as stated, as it exists. And one of the greatnesses of being able to teach international humanitarian law is the ability to say to students, never take law as a given, develop a vision for a better international humanitarian law. And I think that in answer to your question, if there was a vision, it would either be trying to calibrate the deaths in a proportionality metric, which I think would be quite difficult to do, or to devise another scheme entirely. I mean, I think because we have the principle of proportionality, the game is already half won by the virtue of the fact that it's there. It just is in how it's interpreted. And I think one of the great difficulties that all of us have had in watching events unfold is that international humanitarian law doesn't seem to have a restraining function. It simply seems to have a justificatory function for the actions of states. And I think part of my lecture today has been designed to say we really need a rethink about the law we so confidently apply. I can't believe there's no more questions. There you go, Heather.
Okay, I'll ask a question. Yes, Heather Haven with the College of Law. It's interesting because when I'm looking at this proportionality, or at least what seems to be articulated in the 1949 protocol, it does, you know, we're after World War II, we've had these horrific bombings that have happened, and it just seems that as we're moving forward and we think about that proportionality, you know, military, how do I say this? There has been a lot more precision maybe in the types of incendiary devices, in, you know, bombing, in things that we can do. You know, you mentioned drones or targeted things. You would almost wonder if when we're looking at proportionality, it should actually be decreasing because of the precision. And I'm just not sure if there has been a lot of discussion about how proportionality on a micro scale would change based on kind of the level of technology that we have for warfare, you know, in general. I'm sorry, I'm not being very articulate here, but it just, this was striking me as that whenever we look at these protocols, we're looking at when they were passed in a particular time, history, context, and that as technology or improves, that calibration would have to be different.
Yeah, I mean, I think that that's a hugely valid concern. I mean, I think that the difficulty for us is that we don't know the full scope of how proportionality is working behind the scenes. I would love to know how many actions governments have called off because they have said proportionality would be violated in this instance. So we're actually getting raw data of one side, but we're not getting the flip side of the coin. And I think it would be interesting to have that, but I'm not sure that that would even be made available even after 30 years. But that's all the more reason why I think we need an adjustment to current practice, because, as I say, the overwhelming impression of non-international humanitarian lawyers is that international humanitarian law is simply there as a validating tool, and every attack has an explanation for their military objective and then an explanation as to why the proportionality is there. I mean, it's very rare for Israel to have put out that notice of regret for the episodes in December of 2023. But it's not just Israel, it's the high contracting parties of the Geneva Conventions, which, by the way, includes all states. They are the first universal treaties. And so I'm very interested to know what they're doing behind the scenes. If they're willing to come forward and let us know, I'd be more than happy to work with them on that study.
I The principle of proportionality seems to be particularly relevant to violence, but does it extend to economic violence, things like sanctions?
No, it's very, very focused on the idea of killing and the loss of life. I mean, I think it is interesting because I think, again, our understanding of the human being has changed now, and there's a big question about whether or not it should compute psychological harm. What about the reverberating effects, long-term harm, particularly to children who have survived? But I think that the nature of the principle was extremely conservative in what it was trying to do. And all I'm asking today is it doing a good enough job on that score? And I'm searching for a satisfactory answer to that. Thank you for the question.
Hello. Thank you for your talk today. My question would be, do you think that the idea of proportionality has come up since October 7th and repeatedly throughout? I remember Piers Morgan bringing it up with guests on his show many times.
Sorry, who are you talking about?
Piers Morgan. Yeah.
That well-known legal sage.
Yes. So do you think at any point the topic of proportionality became kind of silly, given the blatant, disproportionate loss of life to civilians and infrastructure and hospitals? Do you think at any point it became kind of a silly topic of conversation, given the entire context of what was happening and what continues to happen?
Did you not just hear the lecture I gave?
I did, yeah.
I mean, I think you're, sorry, I don't mean to take a shot at you, but I think that, yes, I definitely think that there could have been more vocality about proportionality. And one of the things that's very interesting is that when we've experienced this vocality, it's quite a muddled understanding of the law. Now, one issue that we have to contend with is, has international law become too complex? That only if you take the Sallows seminar will you understand it. And I think that that is a real danger of adding layer upon law, because the more laws you manufacture, the more likelihood states are going to find an opportunity to exploit laws to their own advantage. Remember, international lawyers are no different to lawyers per se. They deliver for their client. So hopefully this will make some small corrective to that set of omissions that you have properly identified.
Thank you.
Hello, Dwight Newman from the College of Law. I want to ask you to reflect a bit on the moments of legal development, connecting this to the history of international law, and, which obviously you study as well. Have the moments at which international humanitarian law has developed more been more at moments of more moral agreement amongst more actors immediately after the Second World War, say? And do we have those conditions today in a way that would allow for the kinds of developments you're urging? Or what would be good conditions in which to get towards greater development of international humanitarian law? Yeah,
it's a great question, Dwight. Thank you for that. I think that it is very noticeable that in 1949, they were very concerned about the civilian population, but they don't actually articulate the principle of proportionality. So one of the startling elements of this study has been that proportionality is only articulated in 1977, which is extremely late into the 20th century. But actually, when it was enacted in 77, numerous states came forward and said, oh no, this proportionality principle is already there in customary international law, and all the treaty is doing is expressing it in conventional form, which is why I revert to conventional expression. But I think that part of the difficulty for me is that states don't seem to necessarily follow every single episode of every single conflict. Remember, Gaza is one of many conflicts that are going on. Ukraine is on the books, Congo is on the books, et cetera, et cetera. And so the question really has to be asked is the idea that as high contracting parties, as the mainstay of these conventions, must they really be the oversight for every single conflict all of the time? That's one interpretation of what the Geneva Conventions are saying, that high contracting parties must ensure respect in all circumstances, i.e. every conflict. I mean, is that really realistic, is a good question to ask. I think my fundamental instinct is we have a principle here, we need to work with it. It's not enough that it's on the books. It needs to be properly understood, studied, talked about, elaborated, exchanged with, and hopefully papers written about on it for its reform.
Hello, I'm Hannah Work. I'm a first-year law student. My friend and I came up with this question. I'll read it out here. In your opinion, how does the discussion of proportionality change, if it does, since Trump's statement about buying and owning Gaza? Do you believe that this changes the narrative about Israel's involvement in the genocide against Palestinians?
Sorry, can you just read that again?
Yes. In your opinion, how does the discussion of proportionality change, if it does, since Trump's statement about buying and owning Gaza? Do you believe that this changes the narrative about Israel's involvement in the genocide against Palestinians?
No, I don't think it changes the narrative, and I don't think Trump's designs on the Gaza coast have any bearing on what I've been saying. Sorry to disappoint.
Hi, my name is Maurice LaBelle. I'm a faculty member in the College of Arts and Science, Department of History and International Studies. I'm wondering if you can connect your discussion of proportionality with the ICJ case of genocide against Israel. And where does that particular evaluation or case fit into some of the wins that you're contributing to?
So I've studiously avoided the genocide case because part of the difficulty for international law has been these really critical norms such as genocide and torture become complete overtakers of the public debate, when actually Israel is not only bound by the Genocide Convention, Israel is bound by the Geneva Conventions and the norms of customary international humanitarian law. It's not mutually exclusive. So Israel has to be bound by both those norms, which was my response to the earlier question. And I think that that is the critical element. The Israeli judge in the genocide case made the statement that actually this is better looked at under the statements of international humanitarian law. But my view is that one of the parties of the Genocide Convention has made the view that, genocide may be taking place within the context of the conflict. That is a separate question to, is Israel complying with international humanitarian law? There was a time when genocide was connected with the idea of war and armed conflict, but that has now changed. Genocide can occur outside the context of an armed conflict, and that is what that situation is addressing. So I don't think it's actually dominating or affecting the debate with respect to what I was doing today. I think the critical point is to make space and make room for understanding what are the obligations of IHL, and in particular, what does proportionality demand? And that's what I wanted to focus on today.
Can I ask a follow-up question? It's just to maybe zone in more specifically on the relationship between proportionality and genocide. Because genocide is in part measured by the lack of proportionality, isn't it?
Well, genocide is measured in accordance with the definition of the Article 2 of the Genocide Convention. I guess what I might say on that point is that it's probably likely that it's macroscopic proportionality that we should be looking at, which is the amount of violence that Israel is committing as a whole, rather than the granular microscopic proportionality that I've been trying to focus on today. I'm happy to talk on the genocide case, but the lecture was about IHL. And as you'll see, I avoided genocide until Q&A. Yes?
I just have a question. What is a proportional form of self-defense according to international law, when it comes to resisting occupation, and I'm talking specifically the Palestinians being occupied in Gaza, and what would it look like for the international community to form a set of laws that see Palestinian resistance, including armed resistance, and the strive for sovereignty as legal and legitimate?
Again, I think that question is addressing the macroscopic point. I mean, this is why there are so many difficulties, that the idea of proportionality operates in many different contexts, right? And I'm trying in the lecture to isolate the idea of what proportionality is trying to do in IHL. You're raising an issue about, do the Palestinians have the right of resistance against occupation? And that, to me, comes under the possibility of the laws of occupation and or the rights of the Palestinians under the Jus ad bellum, which is dealing with macroscopic proportionality. In the lecture, I said it's very difficult to imagine how you measure the violence of an entire military operation. Now, international lawyers will tell you that's what the law is, but it's very difficult to know when disproportionality starts occurring in the course of that military operation. In many senses, I think I'm on firmer ground when I'm talking about disproportionality in this much more limited context. But I'm happy to talk with you after the lecture's over about the possibility of what that proportionality might look like and what you have in mind.
This is on behalf of the students at the college. Let me thank you very much, Dr. Kritsiotis, for your fascinating perspective on this important issue. Thank you so much. Thank you.